All right. Good morning, everybody. Now is the time set for oral argument in cause number CATX 150008, SolarCity Corporation versus the Arizona Department of Revenue. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, you can be a YouTube star in a couple of weeks. How's that? Counsel, each side will be entitled to 20 minutes, the standard allotted time, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any of that time, please let us know so we can try and keep from taking up all your time. However, ultimately, your reserving of rebuttal time is your responsibility. We have reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and the issues attendant to this argument. We let you know that so you can kind of figure out how you think you need to orient your argument accordingly. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, counsel, you may begin.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. I represent SolarCity Corporation. With me at council table is Bart Wilhoit from my office, as well as Court Rich, who represents Sunrun, the other co-plaintiff in these consolidated cases. I will confess to having argued well over 100 appeals, but I don't recall ever arguing one where there were two parties who had both appealed, and I certainly don't recall ever reading as long a briefs as you've had to deal with in this case. There were 6 briefs filed in this case, and they're very lengthy. There's a considerable overlap in those briefs, and I understand that. I'm going to focus my argument right now on the appeal that we filed on behalf of SolarCity and Sunrun. In the course of that, however, because of the nature of this, and I have to reserve rebuttal, I'm going to also talk about why I believe the tax court's ruling below was correct to the extent it found that the Department of Revenue lacked assessment jurisdiction, which obviously gives rise to the appeal that we filed. This case, in all fairness, and I will try to save 5 minutes for the record, in all fairness, this case involves an overreach by the Department of Revenue. I think that may be the kindest way I could describe what happened in this case. Starting in 2008 and 2009, my client and Sunrun came into Arizona and started leasing and selling rooftop solar energy systems to customers. And until this case, which came to light in the middle of 2014, no one had ever claimed that such property should be taxed. There's a very simple reason for that. There is a statute enacted by the legislature which has the exclusive authority under Article 9, Section 11 to enact such statutes that said very specifically how rooftop solar would be dealt with for property tax purposes. Thus, no one at the Department of Revenue and no one in any of the Arizona counties ever sought to impose a tax on such property because of what the legislature wrote in very clear, unambiguous terms. Then this case came along, all started by a memorandum that was written in April of 2013 by a single employee of the Department of Revenue, whom we deposed, and who admitted that the distinction it drew between owned systems and leased systems, which was the predicate on which this taxing overreach took place, did not exist in the language of the statute nor in anything involving its history or its intent.
So what was the authority or predicate for the determination in that email?
In the memo?
Yeah, in the memo, excuse me.
Well, that's precisely why this lawsuit was filed, because we don't believe there was any legal authority. And in fact, the industry and others wrote letters to the Department of Revenue outlining the very law we've cited in these briefs, namely Section 4214-151, which is the gateway statute under which electric generation properties are taxable. And it is under that statute that the department tried to pigeonhole its attempt here to overreach and tax these things for the first time.
Well, the argument posture that we're in today is rather difficult because you're arguing, at least I perceive you're arguing issues that you've won on.
Correct.
So, I mean, at least at this juncture, I'd rather hear from you about why the trial court was wrong in what it did to your client, and then I'm sure that you'll have more than enough time to talk about the other side.
I'll do that, and I'll focus that, Your Honor. I don't think it's possible to divorce that history from where we are. Nonetheless, I appreciate the question, and I'll focus my presentation on that. The reason we believe Judge Witten's ruling is incorrect is because it is not supported by any law. It is not supported by any facts. No evidence was presented. And it contravenes all the canons of construction, and most importantly, the canon that laws are presumed to be constitutional. Ironically, that argument is being advanced in this case by the Attorney General of the state of Arizona on behalf of a state agency. After a statute had been adopted by two chambers of the legislature, signed by a governor, and then amended.
I noticed you didn't cite any authority that says the Attorney General. I didn't see any authority, excuse me, that the Attorney General, maybe I missed it, the Attorney General has to defend, cannot challenge a statute of the state as unconstitutional. Did I miss something?
Yeah, I think you did, and I would direct your attention specifically to the case that we did cite in the brief, which is a case entitled, if I can get past all the head notes here, DeVries versus State of Arizona, which is a case that construed the more modern version of what we now have, which is an amendment to ARS 12-1841 that requires a party, it says this, any party must meet these requirements if they allege a state statute, ordinance, franchise, or rule
I did see that.
is unconstitutional.
I did see that. That's the one that says you got to let the legislature know.
Right. And you've got to tell the Speaker of the House and the President of the Senate, and there was no notification ever made.
I understand that.
There was no issue raised in the disclosure statement. There was no affirmative defense raised in an answer. This came up in the briefing.
So let's move on to the merits, though, I think.
Okay. The merits of that are that, in effect, Judge Witten's ruling, if you can make sense of Judge Witten's ruling, you're better men than I am. It is nonsensical. Its analysis of the uniformity clause is gibberish. It is predicated on a factual assumption that was never even advocated by either side, namely that somehow there's a difference in treatment based on how much power these systems generate and is used by the owner whose house it's located on. There's no such evidence because it's not true. The record establishes without any debate that these systems are designed behind the meter. They are designed to produce power for the house, irrespective of how much power the house actually uses or how much gets sold back to the utility company by the customer. And by the way, that's not my client. That's not Sunrun. Irrespective of that, all this property is treated exactly the same. There is no... The hypothetical that Judge Witten postulates is simply not in the record anywhere because it's not factual.
So the distinction is not between homeowners who have the solar panels and field facilities. That's not. That isn't the basis of the uniformity problem. It's different. It's different homes based on the different usages.
Well, the only way it's a great question because
and I'm struggling.
I understand. I understand. Well, Judge Witten's ruling doesn't articulate that characteristic or that comparison class, but you're correct. The comparison class that ultimately falls out of this analysis is the class of properties that are valued under 4214-155, which are large-scale renewable energy projects. I represent several of them. Thousands of acres of solar arrays. They sell their power on the grid and all of that. Versus the class of rooftop solar, which the department wants you to consider in the aggregate, not as individual locations by individual owners, which is not how they're operated or used. But that truly would be the comparison class that I would be talking about and our briefs talk about in terms of the uniformity clause comparison, because that doesn't meet the requirements of America West or any of the case law that we have on that subject, including a case you co-authored in the Citizens Utilities case. The analogy, however, that Judge Witten drew was that somehow there's a difference between systems that use, he gives this house A, B, and C example, which is, to me, there's no evidence in the record to support it at all, which is all the more proof as to why that ruling is not correct. The other argument that Judge Whitten, because he said and or, he said it violates Article 9, Sections 1 and or 2 of the Arizona Constitution. 1 is the uniformity clause. 2 is the so-called exemptions clause. And that argument is never really articulated anywhere. It was never really developed below. And even in the briefs, it hasn't been very well developed. Because what it requires you to assume is that, in effect, what the legislature did is not what they said they did. They didn't grant an exemption. In fact, if you look at the airport properties case, there's a great discussion in that case about what exemptions look like. Specifically, and this is not in the briefs, but it occurred to me as I was preparing this, this is this court's decision, airport properties. Article 9, Section 2 of the Constitution provides the best examples of what are tax exemptions in the constitutional sense. And then it goes on and lists those and says, these provisions all cut across diverse categories of otherwise taxable property and insulate portions of each from taxation based on fundamentally legislative considerations that may or may not be related to the defining categories of the defining criteria of the categories affected. For example, it talks about charitable property, property owned by churches. Those are examples of exemptions. The legislature didn't grant an exemption.
If I understand the record and the law here, the legislature has plenary authority to tax property that is not exempt.
Correct.
And it seems as what they did here, they require that the assessed value be 0.
No, they didn't say that. What they said was, it shall be considered to have no value and add no value to the property on which it's located. Now, why would they say that?
Well, I think the point is that the end result is that no tax is...
No, I don't agree. There's no evidence in the record to support that inference. In fact, the evidence in the record establishes that the assessors value all real property in the county every year. Now, if this property is attached, like a water heater is attached to my house, when I sell my house with my water heater. It's wired into the house, it's plumbed into the house, it belongs to the house. And it's part of the purchase price that the seller pays, or the buyer pays when they buy my house. If they buy my house with a solar system on the roof, it is exactly the same. It's affixed to my roof. In fact, the statutes even use the word affixed. And it's wired into the building's electricity.
Because I think you kind of picked up right with me that I'm not...
Oh, no, I'm not...
That I'm not trying to have with you is let's assume that the end result is that the panels add value. The legislature can do that, and that's not a violation of the exemption.
They can, I believe, because they have the plenary authority you referenced a moment ago, and that plenary authority says they can prescribe how things will be taxed. And that's all they did here.
And a theoretical question I have is, can you have a negative violation of the exemption clause? I mean, it seems like, at least as I understand it, that the legislature would only violate the exemption clause if they tried to tax something that was exempt. I don't know how the legislature can violate the exemption clause by not taxing something.
That's actually a very good point. I mean, you're turning the analysis on its head, which is really, I think, the proper way and the way it would normally come up. In fact, if somebody was challenging an enactment as unconstitutional under the exemptions clause, that is how it would arise. And in fact, the cases that I'm aware of where that issue has come up have all arose under that set of facts.
So if the legislature designs the law that tax, if something doesn't add taxable value, then that's acting on that property. That's not exempting that.
Yeah, for
property.
example, if the legislature said property owned by churches is all of a sudden taxable, where
Yeah.
churches are clearly specified in the Constitution as exempt from taxation and their property is exempt, yes, then I think they would cross a line that they couldn't cross. Because you didn't ask me to cover the arguments in support of Judge Witten's ruling, I'm going to save my remaining time unless you have questions right now. Thank you.
May it please the Court, Jerry Freeze from the Department of Revenue. I'd like to start out by making clear that the Department below did not challenge the constitutionality of the statute at issue. The statute at issue, when it was passed a decade ago, had to do with solar systems placed on residential properties. And so what the exemption does, it says when the local county assessor, and it doesn't say the assessor specifically, but it says when properties are valued using standard methods and techniques, that when you value that property, and in this case it would be a home, the assessor cannot attribute any value to a rooftop system that the homeowner bought and put on their property. That system has no value and adds no value to the underlying residential property. And that's what that statute had to do with. And we're not challenging that. We believe that to be constitutional, and it's certainly not at issue today. What's at issue today is we have the rooftop industry trying to glom onto that statute, and they're trying to say we as a for-profit business, we get the benefit of that. And our corporate...
I'm sorry. So
Yes.
you're saying that we could reverse the Superior Court on the constitutional issue?
That was not an issue below. I don't know why the court ruled what it did. No one argued that below. We didn't argue that.
Should we take that as a confession of error?
No, we argued that a confession of error on the part of the court, not on the part of the department.
I'm not saying the department. No, I'm not saying the department.
Correct.
I'm not saying
I think the
so
court
you're,
erred.
So you're basically conceding that regardless of how we rule on the other issue,
Correct.
That the court was wrong to declare the statute unconstitutional.
Yes, I agree. No one argued that. No one argued that. And in fact,
So the
Okay.
and it was just simply wrong. It's just flat out wrong. It was
Okay.
not briefed. It was not argued.
That makes the decision much shorter.
So the accepting issue and the uniformity clause issue, those issues fall out as far as you're concerned.
Well, they don't fall out because they're not applicable when you talk about valuing a rooftop system owned by the homeowner, because there is a constitutional exemption for household goods. There is an exemption for that. And so a piece of equipment owned by a homeowner is exempt under the Constitution. But if it's owned by a for-profit company, it's not exempt under the Constitution.
Fine owned by the homeowner, owned by the company.
Well, if I'm a homeowner and I buy a system and I put it on my home, the statute says very plainly, when the county assessor values my property, that system has no value and adds no value to my home.
If
So,
it's there.
if it's there,
If it exists.
if I own it,
Not whether it's paid off or not paid off.
paid off, not paid off, lease, if I borrowed it, whatever it might be. If I own it, if I'm the homeowner, and this is what the statute had to do with, the county assessor, it's like putting in a pool. It's this,
But counsel, and you're talking about C2 here in 11054. It's designed for the production of solar energy primarily for on-site consumption or considering of no value and add no value.
correct.
The issue seems to be not who owns it, but whether it meets that definition and whether that's owned by the homeowner or leased by SOLARCITY and Sunrun. It doesn't fit that definition.
Well, I think it does fit the definition. I think it's twofold. Number one, under that statute, it talks about property which is valued using standard methods and techniques. That would include a home. That doesn't include personal property owned by a for-profit corporation. For-profit corporations have equipment, and whether the department values the equipment or the county values the equipment is valued by statute. So as a matter of law, that statute cannot apply to a for-profit company's equipment.
So you're not arguing the statute is unconstitutional.
I'm not
We
arguing
don't have to
that.
address that.
Correct.
What you're arguing is that that statute doesn't apply when the taxpayer, meaning the people selling or leasing the panels, are only leasing it to the homeowner. In that case, you're saying that it is taxable. It doesn't fall under that provision.
That's correct.
So that's that, okay.
It falls under two different statutes. The full cash value is defined as the value set by statute. If no value is set by statute, then it's the value determined through standard methods and techniques. There's no statutory value for a home. Homes are valued using standard methods and techniques, the sales comparison approach. Personal property owned by a for-profit company is valued under two different statutes. It's either valued by the department under 42-14-151, which is an electrical generation company, and they generate electricity, some or all of which is sent over the grid, or if not valued by the department, then it's valued by the local county assessor. And that, too, is a statutory valuation method. So 11054, as a matter of law, does not apply to this equipment.
So your basic argument is that SolarCity and Sunrun operate an electrical generation facility that's dispersed across all the homes of all the people who lease solar panels. And that's just like a field of wow.
Exactly.
Wow.
That's exactly right.
Okay. But let me make sure,
Sure.
You probably may have heard me if you were in the earlier argument that I have been accused of having a firm grasp on the obvious. I want to make sure that's right. We do not have to address the Constitution. We can reverse on and we have to address it. We can reverse on the constitutionality of the statute, right?
No. Well, you can reverse on that, right. The argument that the department made below was if you think that statute applies to their equipment, to the plaintiff's equipment, it would be unconstitutional as applied to them, because there's no exemption in the Constitution exempting that equipment.
Okay. So you were arguing that it's unconstitutional if it applies
As applied to their property, correct.
Okay. Now I got the firm grasp on the obvious. Okay. Thank you.
I thought it was very clear in the briefing, but
That's what I thought the briefing was, too.
I did, too.
But when you got to oral argument and you said, well, you agree it's not unconstitutional, I said,
Well, I had to clear it up because of the argument made by the appellant. By the way, I do hope to save 4 or 5 minutes. I'm an appellant, too. I hope to save 4 or 5 minutes. Now I can get to my outline. The bottom line is if you own and operate a business in this state, your tangible personal property is taxable. That's the law. And the fact of the matter is billions, if not tens of billions of dollars of electrical generation equipment in this state is valued every year, whether it's solar, coal, natural gas, wind, whatever it might be. And the fact of the matter is that billions, if not tens of billions of dollars of non-electrical generation equipment is valued every year. And that includes mining equipment, manufacturing equipment, vending machines, and all that sort of thing. And the plaintiff's case in chief is basically, we're the exception. We don't have to pay taxes on our property. And for that to be the case, they have to point to something in the Constitution.
Didn't you say that this is the property of the homeowner?
It is not. This is the property of SolarCity.
Wait.
Yes.
I thought I asked you earlier, does it matter if it's leased or owned, if it's paid for or not paid for? It's the property of the homeowner, and you said it's the property of the homeowner.
Well, in the hypothetical, if you are a homeowner and you buy something, whether you buy it with cash, whether you pay gold, whether you pay chickens, whether you take a loan out for it, whatever it may be, if you own it, if you operate it, it's yours. The county assessor cannot value it.
Okay.
Cannot value it.
Well,
Distinguish that from the situation earlier where it's put on the home, it's owned by the owner, and it's not the owner's, or it is the owner's?
Well, it is. If the owner owns it, it's theirs.
Okay, so the owner owns it, excuse me, let me,
Right.
one final. So the owner owns it,
Correct.
but for purposes of taxation, the seller owns it. The person who sold it to him owns it.
No. If I buy a piece of equipment from SolarCity and I put it on my home and I own it, when the county assessor values my home, if my home has a $500,000 value without the equipment, and then I put a $50,000 set of solar panels on my home, the home is still valued at $500,000. That adds no value to my home. You cannot value it.
And the owner is the one who's taxed on that item.
Well, the owner of the home, right, but he's not taxed because it has no value. So he's
Right.
taxed on the underlying home, but you cannot attribute any value of the solar panel to the home. You can't value it. They're trying to glom onto that and say our for-profit equipment, our $1 billion worth of for-profit equipment that we use to compete with the local utility, you can't tax it.
Yeah, I think there was a failure to communicate.
I think
really.
you're right.
I was going to raise that because that was your question. And then when you answered, you started talking, it doesn't matter if they own it, they take out a loan on it, and then you said, or lease it. And I said, I was going to say, wait a second.
Right.
I thought your point was that if they lease it, if Sunrun or if SolarCity leases it to the homeowner, then that makes the difference.
Correct.
Is that right?
That's right, yeah.
Okay.
It was,
It was just a slip.
If I lease a car, if I lease a car, maybe that's not a good example.
let's talk a generator. Let's say I have a generator, and
Sure.
I buy a generator, and I have it in my home. Can the county assessor value it? Can't value that. I'm a homeowner. If I'm a for-profit company, I have a generator in my mine or in my manufacturing facility, well, how can that be? Because that's in the Constitution.
So if you're a homeowner that owns solar panels that generate electricity, but they're leased, then the lessor is responsible for taxes on that. But if they own an electric generator that is gas-powered, then they don't owe a tax on it. Then the lessor does not owe a tax on it.
Whatever the homeowner owns is generally going to be exempt when it comes to equipment because of the constitutional exemption. But if a for-profit company owns it and it's part of their inventory and they use it to generate revenue, and that's the nature of tax in this state. If you own real property or personal property, it is taxable.
So if you had, I'm not trying to be funny, but if you had a company like Stove City instead of SolarCity,
Sure.
that sold or that leased or sold stoves to homeowners, that they wouldn't need as much electricity then the owner of all those stoves would then be in the business of generation of heat.
No. If I don't think so.
I don't.
Right.
If your argument is that SolarCity and Sunrun are electrical generation facilities that are just dispersed out among everyone, then if a company sells coal-fired furnaces or leases them, then don't they run a coal-fired generation facility?
No, because the issue here is a property tax. If you sell a solar panel or a wood stove or whatever it may be to a homeowner, there'll be a sales tax on that. The issue is now in the possession of the homeowner is a subject of property tax.
No, but what if you lease a stove?
If you lease a stove, there may be a TPT, a transaction privilege tax on the leasing of it, but when we talk about the electrical generation statute, it talks about owning and operating and generating electricity, and the electricity is then sent over the grid. So, wood stoves, heat over the grid. Yeah, I mean, the analogies can go on forever, quite frankly.
So your argument hinges at its core that SolarCity and Sunrun are operating an electrical generation facility.
Correct.
They're just like the field, except it's all over.
That's exactly
everyone's
it.
home.
That's exactly it. They are in direct
On
competition.
the possibility that they may send electricity out over the grid that makes them taxable.
No, they do. Well, they're taxable regardless. The issue, if they send electricity over the grid, they're taxable by the department. If it's not sent over the grid, then it'll be taxable by the local counties. It's still a for-profit piece of tangible personal property, and then it'll be valued by the counties.
Only if it's leased.
Pardon me?
Only if it's leased.
Well, I don't like the word lease. I like the issue owned. Who owns it and operates it?
That's how I started this.
I understand that. That's why we got
That was right.
down that road.
So let's look at 14151B then. It says generation of electricity means the process of taking a source of energy, including coal, that includes solar, and converting the energy into electricity to be delivered to customers through a transmission and distribution system.
Sure.
The solar, as I understand it, the solar panels that are on people's homes are behind the meter. They go first to the homeowner, and what goes out to excess generation is incidental.
It's not incidental. There's nothing in the record to that effect. The fact of the matter is a vast amount of energy is sent out over the grid by these systems. These companies wouldn't exist but for the ability to send out electricity to the grid and get a net credit for it. That's why we have a lawsuit in federal court.
Suncor's purpose is not to provide solar panels to allow for electrical generation in a private facility, a private home. You're saying their purpose is to put them up there and then have them generate electricity at a rate higher than they need, because that's where the punch is for these appellants, is because they make the money on what goes back out onto the grid.
No, the appellants don't make the money about what goes out over the grid. It is a credit that is enjoyed by the homeowner.
Right.
So it's a net credit, but the company benefits from it. The electricity generated by their equipment that they own and operate is both used on-site and is sent out over the grid for use by other people.
Basically saying the marketing idea is that, one, the homeowner gets the benefit, leased or bought. The homeowner gets the benefit of saying, I'm generating my own electricity. I don't have to pay APS or SRP for that electricity, as long as the panels are sufficient. And I'll also get, ideally, a rebate or refund for any electricity that goes out from the excess electricity that goes out, and that's the marketing why people buy panels.
Sure.
Okay.
You get a net credit.
Well, let's come back to B. And the end, it says electricity to be delivered to customers. That makes it sound as if the electricity that the ultimate end user gets, that bit of energy, the excess electricity that goes out to the transmission to some other customer of APS or SRP. That's not SolarCity or someone's customer.
It's not relevant. The statute doesn't say that. The statute is very broad. It says if you own electrical generation equipment.
So it is to any customer of anyone.
If you generate electricity that is sent over the grid that is delivered to electrical customers, it is taxable by the department. That's what it says.
And you are an electrical generation facility.
You are, whether you generate 1 million watts at one major site, whether you generate 20,000 watts at 500 sites, or whether you generate 200 watts at 25,000 sites. There's no basis in the Constitution for distinguishing between any of that. What there has to be in the Constitution is an exemption for their equipment, and that is not in the Constitution, not even remotely, and it's therefore taxable. I'd like to talk about the sanctions issue just briefly. The events below in the trial court, I assume the court read the record below. The events that took below were outrageous, quite frankly. I mean, from the beginning day that they filed their complaint to the very end of the lawsuit, both plaintiffs and their in-house counsel and their case counsel did everything they could to keep information from the Department of Revenue. We had an eye toward getting this matter heard quickly and efficiently, because a lot of people are implicated by this. A lot of companies are implicated by it. We have 15 companies lined up with lawsuits. We have school districts that are collecting taxes that will have to pay a refund if we end up losing. And the outrageous thing about what happened below was when they filed in federal court, they filed their federal lawsuit. And they filed that in March of 2015. And then a month and a half later, they did their disclosure in the federal lawsuit. And they disclosed a treasure trove of documents that we've been seeking related to their competitive efforts against local utilities. They disclosed 20 people, you're all aware of this. And the bottom line is, we were entitled to that the previous October. We were entitled to a supplemental disclosure of that information in this case in May of 2015, and we never got it. And what we did get was a motion for sanctions in June of 2015 for trying to get this information that they admittedly had, and that they admittedly say, we just don't feel the need to give it to you. We don't think anything of your case, we're not going to give it to you.
It is an abuse of discretion standard on that, right?
Not under 12349, it's not, it's de novo. And whether it's abuse of discretion or de novo, what took place below is outrageous, quite frankly. And if not now, when? I mean, if you're not going to sanction this conduct, when will this kind of conduct be sanctioned? Because I've been on the receiving end of this time and time again. And it's outrageous what happened below. So a lot of people, again, were implicated by it, and my client had to spend a lot of time and money and effort dealing with something, and especially on the request for admission, where we asked them point blank, do you compete? Admit that you compete directly with local utilities. And they denied it. And then they made literally a federal case about it 9 months later.
Yeah, of course, that's an antitrust case, right?
It doesn't matter.
Well, it does.
The legal standards
Are you an antitrust attorney?
The legal standards for determining whether or not an antitrust violation is committed is different than determining whether or not this is taxable. But there are predicate factual issues and predicate documents and the like.
I understand about the documents. I understand about the documents, but to argue that, well, they admitted their competitors, in the antitrust case, competition depends on product market, geographic market, what kind of conduct is involved. I mean, it could be a very broad geographic market, could be a broad product
it's a different
market.
Legal
Here,
standard.
they're
That's
just
correct.
saying. I mean, so I understand your argument about not getting the documents.
That's exactly right.
Okay.
If
I
you
understand that.
admit you compete, they deny they compete, and then they made a federal case about it. And so,
All right.
all right, thank you. Thank you.
Well, hopefully we're all clear now, but I'm not entirely clear. Index of record 83.
This argument's generating a lot of heat and light for me.
Index of record 83,
Okay.
their cross motion for summary judgment, which, by the way, was filed without a third Rule 56F affidavit, so they apparently had all they needed to cross move for summary judgment, because if they didn't, they should have filed another 56F affidavit, and they didn't. Here's their heading: exempting plaintiffs' solar equipment from valuation under ARS 42-11054C as requested by plaintiffs is unconstitutional. That's their heading. No, they didn't raise constitutionality at all. Moreover, we never sought an exemption. We have never claimed we're exempt from tax in this case, so that characterization is flawed. Let me go back to what I think is the essence of the problem here, something the tax court judge described accurately as tortured. That's the twisting and manipulation of the statutes that is necessary to derive the conclusion that you just heard, which is that rooftop solar, 10 or 11,000 systems on people's roofs, constitute generation of electricity under 42-14-151. It does not. The tax court judge correctly concluded, based on the facts and the evidence, we never get under that statute. If we don't, they have no authority to tax it. They have no authority to assess it. That's what this declaratory judgment action was brought to determine.
And counsel, is it I'm asking for information
Sure.
from under B of 14-151B.
Right.
Does it not fit because it's not delivered to customers?
Correct. Correct. And more importantly, we got to be talking about SolarCity and Sunrun.
Yeah.
We lease the system to a customer. It puts it on the customer's roof. If the customer doesn't use all the power, then under the net metering arrangement, some of that power goes back to the utility for a credit to whom? The customer. My client doesn't earn a penny. My client gets a flat fee payment on a lease for 25 years. That's a contract.
There's also a maintenance portion into that.
They do. They have maintenance and warranty obligations. And by the way, those are all codified by statute, too. One of the interesting things that I went back as I was getting ready to argue this is something nobody has ever cited in this case, is the definitions in 44-1761 that are expressly referenced as part of the definition of a solar energy system. And interestingly, that statute has four statutes, and it says any agreement governing the financing, sale, or lease of a distributed energy generation system is subject to this statute, except people, individuals, who sell their property with a system on their roof. They're exempted from it. They don't have the warranty obligations and all the other things that this statute talks about. But the point is, it was clearly understood by the legislature that people would acquire these things by financing, by purchase, and by lease. These are 25-year leases. They're long-term leases. I don't go lease a piece of equipment from ABC Equipment Rental. I don't lease a backhoe for 30 years. I lease a backhoe for a week or a day. Yeah, that backhoe is subject to property tax. He's absolutely right about that because ABC Equipment Rental's in the business of renting tangible personal property. But my clients are attaching and installing things that are attached to somebody's roof and wired into their house. And they then get all the benefits. So if anybody's selling electricity here, it's our customers. And you want to go tax my customers, Department of Revenue? You want to take the argument to its extreme illogical conclusion and say, well, you're generating electricity, i.e. Joe Blow and Jane Doe and everybody else who has one of these systems. And if that's true, then it's equally applicable to the owned systems.
But in fact, what you're talking about is people who, and this is the question I ask opposing counsel, who may
Correct.
sell.
Correct.
Now, you're being taxed on something that may or may not
Correct.
generate additional energy to put back on the grid.
Correct. That's what they're taking the position, that because of the possibility that some portion of the power will be excess and not used by the customer at the customer's own choice, because the customer may go on vacation for a month and not use any power.
Part-time home.
Yeah, it might very well be somebody who lives in Chicago part of the year and comes out here and spends his winters out here. The point is, if you went and put solar on your roof under those circumstances, yeah, you're going to be selling a whole bunch of power. You, the customer. Whether you leased it or whether you bought it doesn't matter.
So
you're going to get the credit.
So you lease the unit, they generate some amount of power in excess of what their house requires, which is put on the grid, so your client pays the tax. Is that?
No, my client leased a system, installed it on somebody's home, connected it to the wiring in the home, and under an arrangement that the Corporation Commission and the state legislature have worked out, it's net metered. That contract is a contract between the customer who has the system on their roof and their utility company. And if there's any surplus power, it's between them. My client gets paid a fee for the long-term lease or a sale, because they do sell them as well, from the customer. And they have warranty and other maintenance obligations that are part of that fee that is paid. Whether they buy it, the leasing car example is a wonderful example. Whether I buy or lease a car, I still have a warranty.
But this isn't about the profit that a homeowner may get by the refund checks for the sending back through the transmission system excess energy. This is about whether the value of the panels is to be taxed.
Correct, and there's a specific statute
Right.
that says
that,
we
right,
don't.
that
And
is
if I
that
may,
for
I apologize, I'm over, but I want to add one sentence. I do not want to leave unrefuted what I regard as an offensive and inappropriate comment about how we litigated this case. The simple fact is the judge disagreed with them. They didn't meet any of the standards for seeking the sanctions that they sought below. If anybody did, we did, and we didn't seek them on appeal because, frankly, that is a discretionary determination. Even under 349, it still requires clear and convincing evidence, and they don't meet that under any set of analysis that they could posture in this case. Thank you.
Thank you. Thanks, counsel. The argument is appreciated. We're going to take the matter under advisement at this time. We will issue a decision in due course. Thank you for your time. We're adjourned.